Justine Damond murder case goes to the jury. From WBRN Radio and on the Boston Red Network. On Monday, the murder case of Justine Ruchek Damond went to the jury out in the Midwest city of Minneapolis. This case has been the most sensational case in the history of Minnesota jurisprudence as it relates to police departments. It's the most prominent of the murder trial cases that have been brought. There was one other murder trial case in the sister city of St. Paul involving Philando Castile. The police type in that case was acquitted by a jury. Now this case is different and the backgrounds are different there. What you have literally is tampering with evidence, incompetent, inept investigation, a long line of blunders, conspiracy by the Coppers Union here, and what we'll do in this broadcast is highlight some of the activities going on in this particular trial. In general, in these trials, you have the blue wall of silence. That is a given. But when you have a meeting of police types to decide that they're not going to cooperate with the authorities en masse. So let me just recap where we are right now. This is from a local source, the Star Tribune. In closing arguments, both sides called Damond's fatal, faith, I suppose, shooting a tragedy. Jury deliberation has started into Justine and Damond's, what I want to call that, Damond's trial. Deliberation are deliberating two versions of the killing that reverberated around the world. This is an international case, no doubt about that, a cause celeb for police conduct. An officer who acted recklessly when he fired on a woman who called 911. That is the story. Who used his training to stop a possible threat to himself and his partner is a lie. Both the prosecution and defense delivered closing arguments Monday before a jury of 2 women and 12 men received the case of Mohammed Noor. Was it about, let's see, what would it be, 13? About 14 to 15. And a description of the jury. Now, what has happened here? The courtroom was restricted, very small, evidently, courtroom there. There's no audio or visual broadcast of the trial, which is very, very unusual. If we go back to the so-called trial of the century, the people of California versus Orenfeld, James Simpson, it was televised. And this trial should have been televised, and we would not have to be working from second-hand reporting, which the reporting itself only highlights what these particular media outlets want to present. Now the charge is second-degree murder, third-degree murder, and a second-degree manslaughter. This case has tragedy compound on top of tragedy. That was from the state's attorney, Sweasy, Amy Sweasy, in her argument there. Damond is gone because she was tragically and violently gunned down by a copper whom she called for help. From the defense side, dramatic reenactment of the moment. He said, and this is Noor, Damond slapped the squad car, startling him and his partner. There have been various renditions of this particular fairy tale appeared at the driver's side. This is where Damond appeared in her nightgown, period. Raised her arm, and Pluckett said, prompting Noor to shoot, which is an obvious lie. There have been various tales of this. They put on two different neighbors who claimed they heard a loud sound in the alley that night, like a can or something dropping a trash receptacle. Is what they claim they heard. But the problem is these witnesses, on their interviews with the state's attorney's office and before the grand jury, the testimony conflicts. One woman, and hopefully we'll go with this, one woman said basically that she heard nothing. Now she's hearing things. And they were the so-called surprise witnesses. There were two of those. And this thing goes around and around and around to a gang of raccoons making noise in the alley. And this whole slap on the car hood theory came up after the fact. And that's why it's very, very suspicious. Period. And going on here, if there had been a gun in her hand, Noor would be a hero. Instead, we have a tragedy. That's from the defense attorney. There was no gun in her hand. There was no palm print on the hood of the police car. Period. So that would normally end the case. There should have been a palm print there. Then they tried to claim that maybe she used the back of the hand. That's just stretching it too far ahead. So what basically is this whole case rests on, does the jury believe these coppers, or do they believe the evidence? Here's a woman called 911 2 times, then goes out into the alley in her night clothes and is killed by this blackguard Muhammad Noor. This is in itself an insult. Period. And there were 61 witnesses called in this trial. Evidence range, fingerprint analysis to graphic police body cams. Now, one issue also, the police body cams on these two people, Harity and Noor, were turned off. Should have not happened. And also the cam in the police car was turned off. That is the start of, that's a very critical point. If I were on the jury immediately, I would question that. There's no doubt about that. Period. Oh, incidentally, the jury is sequestered during the deliberation process. And the prosecution documented alleged gaps in police and state investigating of the shooting. Now, Sweasy told the jury Monday that the information gives them context to weigh all evidence and to judge the witness's credibility. Of course, the defense would say it's filled with red herrings, slideshows. This is something to distract the jury, confuse the jury, because what the jury has to decide in this case, did Noor deliberately do it? In other words, what Noor's mindset at the time of his actions. That is in itself very, very important. and his so-called training. Now, these coppers are trained to not. He only shot once. They are trained not to shoot once, but several times. They had something called warriors training, which on the order of the mayor has been discontinued. There's still some controversy about that, but because of the training, now this loud noise, you can understand this partner of his, Harity's gun was, he was not able to get it out of his holster, and the fear, this is all concocted after the fact. The defendant's story evolved and changed in the 2 days you watched him on the stand. She said, this is the prosecution, you should put great stock in the fact that Harity did not act on his fear and did not shoot Damond. He did not, nor shot over him from the passenger side of the vehicle. Now, there's some that speculated perhaps he was actually out of the SUV and fired from there. You should put great stock in the fact that Harity did not act out of his fear and did not shoot him. I emphasize that enough. And from the defense, the perfect storm that evening. We are not here to Monday morning quarterback with 20/20 hindsight. That is actually a lie. They are there to Monday Monday morning to quarterback this, in the sense that when they get the evidence that they have, no palm print, no fingerprints of Denora on the SUV, no gun, and evidently the supervisor there claimed she was either drunk or on drugs. There was the toxicology, the reports, there were no drugs in her system. They even searched her house, if you can believe that. There was no alcohol involved, period. And also there was an indication that some woman was going up and down the alley. They have not got that one out, period. So a lot of this testimony was slanted towards the police department. Her father was there, John Ruchek, threw back his head and shook it back and forth. In other words, he doesn't believe these lies. And a little bit about her decision to apparently walk down an alley where she thought a predator was lurking, and using what he described as grace and stealth. She developed as a student of yoga, kickboxing, etc. Now this is from the defense attorney, and I can see why her father was shaking his head. Grace and stealth. I mean, all of this is really unfortunate to slander a person. I don't know anything about her kickboxing. This is the first time that has been brought up, but kickboxing would not have spared her against a 9mm. Let's just backtrack a bit here on the continuing battle between the state's attorney's office and the local police. And this was a problem here from the very beginning. That they had questioned these various officer types about the intermittent body camera usage at the shooting scene and refusal to meet with the state's attorney for questioning. That in itself sets up a foundation for obstruction of justice and a conspiracy. A picture of pervasive secrecy among street officers and their direct supervisors at the scene, but it's unclear how the jury will relate to Nora's state of mind on the night that he murdered Justine Damond. It has become a far bigger part of the trial that I expected that is from some person named Marsha Hallberg, who attended parts of the testimony. What does that have to do with whether Noor shot off his gun? The argument will be that it goes to bias, but it has gone far more than that. Experienced attorneys say they never have seen such a deep conflict between law enforcement agencies and the prosecution. Well, the prosecution is doing the right thing here. There's no question here that the prosecution are accusing many members of the Minneapolis Police Department of a conspiracy to obstruct justice. That's from Joe Freiberg, a defense attorney. I think it's a real problem for the county to be claiming that these officers have entered into a conspiracy to cover up a crime, then turn around 2 weeks from now and put them on the witness stand. Well, that is just a matter of fact of how things go along in these types of situations. And let me finish this article up here. This is a recap of what actually went on. While officers show solidarity with a colleague, that doesn't mean they would lie under oath. Well, they first have to be placed under oath. They were not voluntarily showing up. Forced the state's attorney to impanel a grand jury. Of course, then subpoenas were issued and they were forced to show up. And that itself takes it out of the norm, and that's very, very important here. Normally you would not have that kind of situation, period, in this type of a trial. Now, all the missteps that happened here, a picture of police secrecy went over that, and the source key investigative details haven't been substantiated by any of the 27 witnesses who have testified to date. Reports of a slap on the vehicle before the shooting, and they questioned the supervisor there, Shannon Beretti. Beretti, who managed the crime scene or mismanaged it, testified she never asked Noor about the incident, even though the department policy requires supervisors to take a statement from an officer involved in a shot that was fired. Amongst other details, I didn't feel I needed to, Beretti said, adding that she'd already spoke to the partner, that's Hannity, at the scene. And the assistant state's attorney, Sweasy, asked if it was possible that she could have learned different details had she spoke to him. She goes on, this is Bernetti, it's possible. Bernetti, Noor, and Hannity supervisor tonight had loomed large in the trial. Prosecutors specifically called her out in the opening statement. In the opening statement, what that does is set the whole tenor of your case. And when she was called out there about the body cameras, and Beretti did record some scenes, but the audio was missing. The first clip showed her driving to the scene. She exited her vehicle, told an approaching officer, "I'm on," and turned off her camera. That's very suspicious in itself. Why did you turn it off? Sweasy asked. I don't know. See, that in itself says she's lying. I can't answer that. If the jurors took note of that, that would have ended the case at that point in time. She came out of nowhere in Hannity. This is crazy. These people patrol this area town, and they understand these alleys. In fact, they'd had a call in another part of that same district that very night. Beretti testified that it was the only conversation she had with Harity as the partner of Noor that night. She added that from their brief exchange, she assumed the shot had been fired from inside the vehicle, although she was not expressly told that. This just doesn't add up. The second clip ended in Beretti went to look for Noor. The third clip was filmed 2 minutes and 6 seconds later. Sweasy said it showed Beretti standing outside the front passenger side of a squad car as Noor, whose face was obstructed over by the vehicle, lifted up his left arm towards the empty driver's side door. Was Noor demonstrating how he shot Damond? Sweasy asked. Absolutely not, Beretti said, because we didn't have any conversation about him firing his weapon. She should be reprimanded. Beretti was shown turning on her camera and talking to a lieutenant named Dan May. Dan May was involved from the record here some 20 years ago in a murder of an African American in Minneapolis. Did you find out what direction it had been shot? May asked. He was in his car, Beretti answered on the video. Sweasy pressed Barnetti whether she learned that from Noor. It sounds like you were kind of surprised, as Sweasy said. No, Beretti said. I asked him nothing about the shooting. I don't know why he lifted his arm. Beretti, approximate 3.5 hours on the witness stand, was marked by strained exchanges with the prosecution, repeated revisits of the transcript of her grand jury testimony to reconcile a contradiction. She surprised the prosecution by telling them for the first time Tuesday that she had numerous casual conversations with Harity after the shooting that she never documented. And did this did not divulge at the grand jury testimony that was in 2018, which legally compelled several officers, we talked about that, to appear. Prosecution accused Beretti of originating the idea of a slap, a large sound heard on the hood of the squad car there. According to the transcript, her testimony with the State Bureau of Criminal Apprehension that we read aloud in court, Beretti recalled Harity telling her that Damond had a stunned look on her face, and then he heard a shot. Upon questioning by Sweasy, Beretti testified that Harity did not say anything about noise. And this is where the story was made up. If the jury dissects this testimony in detail, the case is virtually over. Now to the body cameras that were turned off. Testimony revealed that two of the officers broke protocol by turning their body cameras off, and at least one violated crime scene practice because he wasn't fully informed about the circumstances. Now, again from Sweasy asked, this is the chief, Adarnu, who was acting chief at the time, about the body cam policy. He said this is correct. They did have a policy there, and it was violated. The chief testified on the Minneapolis police body camera policy. At the time, officers were expected to hit the record button when conducting traffic stops or any contact where an officer believed there may be adversarial situations that developed. Now, Noor's side tried to say it was in his infancy. Didn't make any sense right there. They also called a firefighter here, who was the first firefighter at the scene with his two partners. Eninger was his name. Said he took over from the officers performing a CPR. But she had no pulse. The woman was dead. And she had no pulse. Sweasy asked for more information about what had happened, would have helped him. He said yes. And this is another major witness here, Genderer. Some officer named Genderer testified he arrived at the scene. There was an officer involved in the shooting, though no one told him about it. Genderer said that he had known he wouldn't have entered because the car was part of the crime scene. Now, Genderer turn on the witness stand caused a controversy when the state's attorney tried to address the fact that he and several colleagues refused to meet with the state's attorney, were forced to by a grand jury. The judge in the case, Quinlan, could excuse the jury to deal with erupting disputes between the prosecution and defense before she was able to ask Genderer if he was one of 20 officers refused to meet with the state's attorney before the grand jury, and whether he attended the meeting by the police union. Outside of the jury, Quinlan asked what role Genderer had in answering a question about conspiracy. We're not saying it's conspiracy. This is from the judge. I'm not being when I asked I'm not being sarcastic. When I asked the term conspiracy, the judge said it is a continual prosecution. This is from the defense attorney. Well, the judge can say what the judge wants to say. The rule the prosecution could not ask about the union meeting, but it's already out there. Now, what Noor claimed, it was a split-second decision, and it wasn't a split-second decision. This Noor had a history of drawing guns on people, but this time he shot and murdered this poor woman. We won't spend time on him. Certainly, as the jury returns, and just a little bit on these surprise witnesses. I talked about that. And who testified they never heard a noise that night. Wait a minute. Oh, they heard noise that night, potentially leading to credence to these coppers. I remember hearing Boom 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 testified Michelle LeBlanc, whose backyard overlooked Damond. LeBlanc said her family was struggling that night because of an 18-year-old daughter that had a brain disorder. She and her husband were in bed with their bedroom windows open. It was in the summertime. LeBlanc said she was either asleep or in a deep sadness when the noise caught her attention. The first noise, she testified, sounded like a city-issued plastic garbage bag being thrown to the ground. Then I heard plump. She said, and she would not have been able to hear a person knocking a hood. A series of noise. Our brains caught up with us. This is just crazy. Was it a substantial noise? She claimed yes. And LeBlanc said the noise occurred in quick succession. Noises, probably by that plural. And the prosecution disputed the theory and tried to dispel it. And this is where a little editorial comes in here. None of the 51 fingerprints lifted from the squad matched Damond's. Now, to the prosecution and their take on LeBlanc. Cutting Lofton, this is another one of the prosecutors confronted with her initial interview. This was with the State Bureau of Criminal Apprehension investigators after the shooting. The investigations had asked her if she heard any noise. This is before the gunshot. And you said nothing. LeBlanc said she thought the investigator was referring to the noise from an alleged assault Damond had reported. She lied. Lofton asked LeBlanc if she read the Star Tribune and spoke to the to Minnesota Public Radio after the shooting. She said yes, so she's on a public record. Asked if she told the investigators she heard pew pew pew. I recall telling one of the investigators that I heard boom boom boom, she said. Lofton stood near LeBlanc on the witness stand with a transcript of her interview as she tried to explain hundreds of people swarming around her house after the shooting, including medics. And the state's attorney walks away and begins talking, causing her to fold. And asked if she met with the defense attorneys. She confirmed she had. Did you want to be helpful? He asked. I wanted to tell the truth. She lied. The Lofton, he's the state's attorney, asked her to did she follow news? She said yes. She testified, adding that the shooting had been earth-shattering and defining a part of her life. LeBlanc said that she called both County and Plunkett about the case. And another witness, Tori Emerson, who lived next door to LeBlanc, said he was in bed with the windows closed when he heard the sound. How in the hell would he hear somebody? It sounded like fireworks. Well, there were fireworks. This was around that time of the year, and was not uncommon, evidently, for people to be firing off fireworks. Now, I'm not sure how readily they're available. I can recall driving through Missouri, and you can buy them 365 days a year. And I'm assuming you can probably order them on the internet. And back to the split second there, the prosecution didn't, this is Sweasy, didn't relent. Again, you had that split second made another decision, she said. You had absolutely no choice, and he claimed no, ma'am. He just lied. Now, to go to the Minnesota Public Radio here, where he testified to fear. We reported this in our last broadcast, and this is a traditional stand of law enforcement that they fear for their lives. And this lie has been told over and over, was told in Chicago. People just simply did not believe it. Norris said he put his left hand on Herity's chest and extended his right arm to fire. He said that moment he feared for his life. That is up to the jury. Did the jury believe him? The jury does not believe him. On the stand, Noor pushed back on those criticism to police. Now, this is we haven't brought this in. This is the use of force experts testified for the prosecution. saying that no reasonable police officer would have perceived Ruchek as a threat that night, and being startled doesn't justify deadly force. In fact, one said they should not have even used a taser. And the focus on training. And the background of Noor, where he moved from out in the bush and the Kenyan refugee camp at 5. At 7, he moved to the U.S. and he lived in Chicago. And he had difficulty adopting to the American civilization. The judge again, however, reprimand. This is the defense attorney trying to reprimand the judge against getting into ambushes of police officers that happen. There's no indication of ambush here, Quinlan said. Plunkett argued that there was a perception that night of the partner. So if the judge said there was no ambush, there is no ambush, period. Let me just go over here. This is from the Minnesota Public Radio. The closing arguments here. And this is by John Collins. Harity, who sat in the driver's seat. This is pretty much the same report here. The defense witness used a use of force expert. This is one of these characters that they had that had testified in a number of trials, but what it boils down to, do they believe him? And they also ex-cop Muhammad Noor, he had been fired by the Minneapolis PD. After the noise, he said he saw Hannity, who was in the driver's seat, reach for his weapon. Then Hannity struggled to get the weapon out, and fear in his eye. And this is just too contrived. 2 police use of force experts testified for the prosecution slamming of Noor's firing in the situation. One said no reasonable police officer would have perceived Ruchek as a threat that night, and that startling doesn't justify basically killing someone. She was in a pink shirt with an X taped on her abdomen at the location she was wounded. Now this, I think, is the actress situation. A woman about roughly, in U.S. terms for Australian people, about 5'7", 5'8", something like that. So they did a little reenactment there. And what else do we have here? That is basically all. The reports are very similar, so I'm moving here from the local newspaper to the public radio station. I also reviewed some of the local TV channels, what they presented, but really it was not very much in terms of what is proven here is basically around intent. In the closing arguments, the prosecution could argue that intentional act of shooting a 911 caller was negligent. And that is the thing, negligent intent, negligent there. And to the training, the 2nd and 3rd degree murder charges are tough to prove, said another criminal defense attorney. And she was quoted named Marcia Hallberg, especially against a police officer who attended most of the trial proceedings, said the defense had painted a vivid picture of 2 police officers worried about their safety. you weren't there type of situation. Had it been a firearm, he would have been a hero, but because because he saved his partner's life, generally people are supportive of law enforcement. Now, this is a contribution from the Associated Press also. Now, the problem here is that this support of law enforcement flies in the face of how the atmosphere of this, surrounding these police officer type killings has drastically changed since 2018. We're in April of 2019 with the convictions in Chicago and various other places that police officers have been fired for lesser reasons there. And then also the criticism of the investigative authority. That's the reason it went to the grand jury. Norris Cross questions resurface about the BCA, as they call it, cop-friendly approach. Now, this in itself it colors the whole case. In other words, it goes beyond just 20 officers assembling and agreeing not to cooperate. It says that the very so-called independent agency itself was police friendly, thus various things have happened there. What agents have characterized as simple police courtesy is viewed as by some as tacit support for police by investigators charged with probing their conduct. Now, this is a problem. You need a truly independent body to investigate there, and this Marsha Hallberg character shows up. Now, she's a criminal defense attorney. That makes sense. So if the jury is feeling, why did they do this, or why wasn't this more thoroughly, or why it didn't that happen, jurors have answered. They will come back into this blue wall of silence. He said, wait a minute here. I said Marsh. That's Marsh Holberg. It's a man, not a woman. I said Marsh. Sorry about that one. No longer on the force, nor is charged with second, third degree murder of Ms. Damond. Key witnesses in the trial have been pulled back the veil a bit on how the BCA worked. The prosecution also exposed some frustration it felt in building the case. A special agent named Peterson testified that he took over as lead investigator 5 months after the shooting. Only 2 officers had been on the scene, had been interviewed. Sweasy, that's for the prosecution, stated that BCA agents refused to do some of the digging requested by the state's attorney's office, including investigating the source of the screaming that spurred the 911 call. Sweasy repeatedly pointed to a number of steps the BCA did not take that would have helped them present a complete case to the state's attorney office with BCA agents' testimony. She painted a picture of police officers receiving a special treatment. I mean, this case is rotten. Now, there will be civil trials and no doubt a federal case under 1984, and perhaps someplace 1984. What are you going to say 85? But a 1984, which could revolve on a conspiracy. Now, they even had some guy named Tim Logo, a use of force expert for the prosecution and former police chief of Charlottesville, Virginia. Logo criticized the BCA's initial investigation as well as the work of the MPD that night, saying that they failed to get a statement from officers at the scene and document conversations with Noor. He also wrapped their decision. This is return of the vehicle back to the Minneapolis Police Department. From the very beginning, the Hennepin County Attorney's Office had a hard time working with them. In fact, the state's attorney was caught on camera at the holiday party saying that he didn't have enough evidence for the BCA at the time. A month later, he convened a grand jury to compel these people to testify. Questions around these sorts of investigations are nothing new. This is from some guy named Kirshner, a civil rights and a criminal defense attorney. What differs this time, he said, is that it spills into public view. No one who was involved in the investigation has any commitment to getting at the truth, Kirshner said. The commitment was to exonerate the police officers. And this is what the prosecution should have made, and they did more or less implicitly make clear. While testimony from some officers may shock the public, it comes down to whether the jury felt Noor was reasonable in his specific moment. This is back again to this Hallberg character. I expect the defense to argue strongly at the end of the case. It doesn't matter, even if for the sake of discussion, other officers were improper by trying to slow the investigation, protect Noor, do those types of things. That's not what's on trial here. He said it's not the conduct of other officers. It's not the policy of the police. It's not the Good Old Boys Network. But that is where he is incorrect. This Hallberg, it is. You have to look at the totality of the case, and that is what is looked at in 2019. This defense attorney is living in a yesteryear. The problem is things do progress, and the mindset of the nation that progresses, particularly after this Mueller report coming out here and other things. There's a large skepticism from roughly 45 to 50% of the public as to what the conduct is and where the fake news is. And we talked about this a little, I believe, in the last broadcast. As far as Patrick Monahan, the late professor there, known for his report on benign neglect, made a very famous statement about assumptions that everyone is entitled to. However, there is only one fact. This is back to the whole argument of science is science. Well, you can't come with assertions, and this is beyond assertions. This is just cover up lies, and these people were caught deliberately in times past. That meeting, and it was in the cafeteria evidently of the courthouse, would have never saw the light of day. So in other words, we're looking now at investigative techniques in future trials will be called out from the very beginning, and procedures by the Minneapolis PD have to be rewritten. The body cameras must be on at all times, and that discretion should not be to the officers, and the cameras in the squad cars should be on. As far as privacy issues are concerned, that can be taken care of by just simply blacking out portions, because again, all these videos and audios are public property, period, after the investigation is concluded. And the local investigation included when the state crime lab. But the problem is, if it's cozy with the local police units, why do it? They should have called in the FBI. And see, this is the whole problem here. There will no doubt be a call for the FBI to investigate for a violation of civil rights on behalf of Ms. Damond there. Let's do the sports very quickly here. And from last night in the NBA, The Nuggets in Denver, the Mile High City, defeated the Portland Trailblazers 21-113. That is in basketball. And in Toronto, the 76ers came alive 94-89 over the Raptors. That series is tied 1-1. And the Blues of St. Louis over the Stars 4-3. That's in the National Hockey Association. And now we'll go to Major League Baseball. Red Sox win 9-4 over the Athletics in Boston. The Cardinals 6-3 over the Nationals in D.C. The Reds 5-4 in New York over the Mets. Atlanta 3-1 over the Padres in Atlanta. The Brewers are 5-1 over the Rockies. The Twins 1-0 over the Astros in the Twin Cities. The White Sox 5-3 over the Orioles, and the Rays 8-5 over the Royals in Kansas City. And finally, the Giants win 3-2 over the Dodgers. And that is the sports, and this will end our broadcast. The Justine Damond murder trial goes to the jury. We'll work a little bit on the editorial thing to lessen the context. This is Boston Red in the Jerry Pippin broadcast booth on the 30th of May 2019. One note, we will have special programming tomorrow, which is May 1st, the International Workers' Holiday. Good day.